one of the more important sources of law, and we've talked about the primary source, which were written down laws, if you will, whether it's the constitutions, the federal constitution, the state constitution, or statutes passed by the federal government or state government. There might be agency regulations, things that are written down. You can search online and there they are. Here's the rule. It's written down. That's a primary source of law. And then we talk about secondary sources of law. And those were where experts wrote down what they felt laws should be or how they should be interpreted and things that we should change. That's kind of a secondary source. And the third source, and it's probably the most important, and it's actually the oldest source, is called common law. Common law, it's here in the PowerPoint under common law, and it's also, they call it judge-made law. And what happened is before there were legislatures, before the federal government existed here, remember our history comes from Great Britain, United Kingdom, and when we were a colony. And so we inherited this body of law from England about how should we interpret things, especially in the business format. Because as colonies, we still had merchants who would buy and sell things. They contract with shipping companies if they manufactured something here in the colonies and they shipped it to England or somewhere else in the world. They would have agreements with the shipping companies. They would have agreements with buyers and sellers and suppliers of raw materials. So there was still commerce long before we were the United States with our own constitution and our own set of unique laws. We were operating under Britain's laws. And a part of Britain's laws come from what they call judge-made laws. They weren't written down by Parliament in England. First, if you had a dispute and if you were a farmer and you agreed to sell your crops to a merchant, to a buyer in the city, and something went wrong, the crops were damaged by rains or something like that, or in shipment they spoiled and were bad, maybe the merchant said, I'm not going to pay for those crops, they're damaged, I don't want to give you any money. And the farmer's like, hey, you promised to pay me money, it's not my fault this happened. And there might be a dispute. Well, you could go before a judge that was appointed by the king and ask the judge, the king's minister, to rule who should win in this dispute. And what English folks are very good at doing is they would write down all of these cases and they'd say, this dispute came before this judge. This is what one side said. The plaintiff said this. The defendant, they told their story. And then based on that, the judge made this ruling. And this went on for hundreds of years in English history, back to the 1500s and 1600s. And they would write down all these decisions. And oftentimes when you see movies or TV shows of lawyers in their office, you'll see behind them, not in my office here, rows and rows of books looking very official looking. Well, decisions made by judges were put into bound books like those. And when another case would come along in another year or 5 years, you could go back to those old judges and say, wow, a similar thing happened 5 years ago. Here's what happened back then, and here's what the judge ruled on and why. That seems to apply here. And so over the decades and the hundreds of years of these decisions being written down, we had a way that was created by judges. When they solved disputes, they would start to rely on, well, what was decided before when a similar case came about? How did we handle it before? Is there a reason we shouldn't just do this one the same way? And that actually became what lawyers and attorneys got good at, and why we have a profession now is our job was to argue to the courts. You know, in the past, something similar to what my client is now saying happened, and here's how the judges ruled. But then an attorney for the other side would say, oh no, this what's happening here in front of you now, judge, is really much more similar to these cases. And so each attorney would become very good at looking at the history of cases and decisions being made in the past and arguing to the judge why their client's version of what was happening today is more like this set of cases therefore the judge should rule this way. And the attorney for the other side would say, oh, no, our case is really much like this line of cases, and therefore, judge, you should rule in our favor. So that became that kind of body of case law, that body of decisions of cases has become known as common law because they happened in what was called a common court of claims. And those cases are still used, and that same body of law is still valid today, and that is still very much how we capture and record cases that are argued. And you can rely on those. If a case goes in a certain favor, a certain line of direction, then today's attorneys can look back over the years and say, Judge, we should win because in the past, people who were similarly situated would win if they had this, and the attorneys on the other side would argue that they were more entitled to it. Those prior cases and those prior decisions are what we refer to as precedents. And that's this word here, precedents, which just means it was decided prior. And stare decisis, I apologize, it's Latin and I didn't pronounce it right. This term means that courts, in order for there to be some certainty, some understanding of the parties that, hey, the law should be reliable. We should be able to know that when I'm entering this decision, this contract, this agreement, I'm hiring somebody, entering a contract or something, I know that if something goes bad, a court's going to interpret this contract in this way because that's how they've done it in the past. It'd be very hard to conduct business if every time you went to court, it was like flipping a coin. I don't know what the judge is going to do today. It could be this way or it could be that way. That'd be very hard. So courts recognizing that, follow this principle that says, we should adhere to past precedents and so that people can rely upon what our decisions will be like into the future. Okay, that's the general theory. Yes, they can change over time. Society changes, norms change, and what's expected changes, but those should be very slow, subtle changes. We want the law and court decisions to be reliable. And that's this principle of following precedents, and that's common law. And for our purposes in this class, when we get to chapters 6 on contracts and 7 on torts, those parts of civil law, contracts or agreements between people, and torts, which is a fancy word for saying injuries. I've been hurt by someone. I've been injured by someone. Those types of law, those civil law claims, tend to fall more under common law for deciding what the result should be, what's fair, who wins or loses, is really based on precedents of earlier cases, not necessarily statutes or regulations that have been passed by the government. More often than not, if you get into a car accident, whether or not that's your fault or the other side's fault is going to be determined based on precedent. If you are in a business and let's say your competitor is right across the street from you, and you think, I'm tired of losing customers to that person across the street from me, so I'm going to go on Yelp and I'm going to say that they're a terrible business, that I went in there as a customer and they took my money or their products were terrible. So I'm saying really bad things about my competitor to hurt them. Well, they may have a claim against me for intentionally causing them financial harm, defaming my business, defaming my products. How that gets decided isn't going to depend on a statute passed by the legislature. It's more likely going to depend on how were past cases like that decided by the courts or past precedents. So torts and contracts tend to rely on common law. So we'll talk more about that as we get into those other chapters, but common law is by far and away the most important aspect from a business owner's point of view in understanding what these precedents are, because that's how we're going to be interacting with our customers in most cases or the public and how those decisions are going to impact us.